Hi, my name is Petal Walker, and I am Special Counsel at WilmerHale, and this is fintechpolicy.org. I want to talk to you today about a federal case in Massachusetts that could have big implications on the CFTC's oversight of virtual currencies. The case is called CFTC versus My Bitcoin Pay. Basically, in this case, the CFTC has brought a complaint against defendants, claiming that they sold a coin under false pretenses, making misleading statements about the nature of the coin. What is really interesting about this case are the counter-arguments that the defendants raise in a memo to their motion to dismiss. Their main argument is that their coin is not a commodity. In order to understand that, we first have to segue to the commodity definition. The commodity definition basically says the term commodity means wheat, then it lists several other items, then, important point number one, and all other goods and articles, then some exceptions, then important point number two, and all services, rights, and interests, in which contracts for future delivery are presently or in the future dealt in. Now, the defendants take this definition in two parts, the goods and articles part and the services, rights, and interests part. What they say is that for the first part, if something is a good or article, it is a commodity. But for the second part, for the services, rights, and interests, it must have a futures contract on it in order to be a commodity. They then argue that in terms of the first part, their coin is not a good or article because it is not tangible, and goods must be tangible. In terms of the second part, they argue that there is no futures contract on their coin. There is a futures contract on Bitcoin. There are actually two. However, there is no futures contract on their coin, and therefore it's not a commodity. Now, the CFTC responds by agreeing with the basic structure of their argument, the two parts, but of course they differ on the substance. In terms of goods and articles, the CFTC says that goods can be intangible. And in terms of service, rights, and interests, the CFTC argues that even though their coin does not have a futures contract on it, Bitcoin does. And Bitcoin is so similar to their coin that that means that their coin is also a commodity. What the CFTC says is that what the Congress intends by listing out those different items is not that they be treated as specific items, but rather as categories. For instance, it says wheat, but that means that every subtype of wheat is also a commodity. Now, the court agreed with the commission, but there is a catch. The court basically agreed with that second argument, that these are categories, and as such, because there is a future on Bitcoin, the other virtual currencies are also commodities. However, the court went further than the CFTC probably would have liked by also saying that that futures requirement also attaches to goods and articles. So it doesn't matter from the court's current analysis, it doesn't matter if it's a good, an article, a service, right, or interest. There must be a futures contract on it for it to be a commodity. So what does this mean going forward? Well, first, the CFTC, if this analysis proves to be the winning one, the CFTC would be able to continue to claim oversight over virtual currencies based on the Bitcoin future. But it does raise a few issues. First, one could easily see a defendant raising an argument that their coin is so dissimilar to Bitcoin that it is not in the same category. Second, it is somewhat different to say on one hand that because you have a named item in the commodity definition that all the subtypes are therefore commodities. That's different than saying because you have one item that has a future on it, therefore the entire category of items are now all commodities. That's slightly different, and that has not been fully litigated yet. And third but not least, elephant in the room. When Bitcoin was defined as a commodity by the CFTC, there was no futures contract on it. There was a swap, there was an option, but there was no futures. Would the courts interpret all derivatives as falling under that category, that term future? That remains to be seen. So is it possible that in the future there could be a coin that the creators could claim is so dissimilar to Bitcoin that it does not fall into that category, and then put a swap on it, and the CFTC would not have oversight over the swap or the underlying market because of a literal reading of the law? That remains to be seen. But that is why My Bitcoin Pay is a case that we should continue to watch.